I have presided over thousands of cases in my career, frauds, assaults, custody battles that shattered families. But the day she walked into my courtroom, I felt something I had never felt before. Not anger, not surprise, but a strange sense of caution as if itself quietly shifted. The bailiff called her name, defendant Karen Mitchell. And the doors opened. She didn't walk in. She announced herself, an obese woman, heavy steps echoing against the polished courtroom floor, breathing already uneven, not from exhaustion alone, but from something deeper, something closer to rage that had been building for years. She scanned the room like she was searching for enemies instead of justice. And then her eyes landed on me. She smiled, not respectfully, not nervously, but with a confidence that immediately told me she believed this courtroom was not a place of law, but a stage where she could perform. I remember thinking to myself at that exact moment, this is going to be difficult. Opposite her sat the plaintiff, Daniel Carter Quiet, controlled, a man who didn't fidget, didn't perform, didn't seek attention. But I've learned over the years that silence in a courtroom is never empty. Sometimes it's loaded. And Daniel's silence felt heavy. Behind him sat his attorney, Olivia Bennett, flipping through documents with surgical precision. She wasn't just prepared. She was already 3 steps ahead of everyone in the room. But none of them were watching Karen the way I was, because I had seen her type before. People who enter a courtroom not to seek truth, but to challenge authority itself. The clerk read the complaint, dispute over damages, verbal harassment claims, poverty-related compensation. On paper, it looked routine. But I've learned something important in my years on the bench. Routine cases rarely bring the most dangerous people. Karen leaned forward before even being invited to speak. That's a lie, she said loudly. No hesitation, no respect for order. The entire courtroom shifted. The bailiff straightened, the jury exchanged glances, and I raised my hand slowly, not to silence her, but to observe her reaction to authority. Most defendants, when interrupted by a judge, show at least a flicker of restraint. But Karen? She leaned back and crossed her arms, as if I was the one being tested. Interesting, her attorney attempted to whisper something to her, but she brushed him off like he was irrelevant. That was my first psychological note. She does not accept guidance, not from counsel, not from the court. Possibly not from anyone I allowed. The opening statements, Olivia Bennett stood first, calm voice. Controlled pacing, she laid out the sequence of events. Harassment incidents, repeated disturbances, documented complaints, witness statements. Didn't exaggerate. She didn't need to. Her strategy was simple. Let the evidence speak. And as she spoke, I noticed something important. Daniel never reacted, not once. No nodding, no shaking head, no visible emotion. In my experience, truly innocent people often want to respond to accusations silently, instinctively, but Daniel remained still. That kind of stillness can mean discipline or it can mean suppression. Then it was Karen's turn. She stood up so quickly, her chair scraped loudly against the floor. I want everyone in this courtroom to understand something, she began, her voice rising immediately. This whole case is rigged. A murmur spread through the gallery. She pointed at Daniel. Manipulated everything. He lied. He twisted the story so he could look like the victim. Then she pointed at Olivia, and she's just here to sell it. Finally, her finger turned toward me. That's when the temperature in the room dropped. And I don't care who's sitting on that bench, she said. This court is rigged. I have been insulted before. I have been challenged before. But what struck me wasn't the accusation. It was the certainty in her voice. The absolute refusal to acknowledge the existence of authority beyond herself. That is not confidence. That is something else. Delusion wrapped in conviction. I leaned slightly forward, not to intimidate her, but to understand her. Miss Mitchell, I said calmly, you will address this court with respect, or you will be held in contempt. A pause. For the first time, she hesitated just for a fraction of a second, and in that fraction, I saw something flicker behind her eyes. Not fear, not regret, but calculation. Like she was deciding whether this courtroom was worth escalating. Then she sat down slowly, but she didn't stop staring at me. And that stare stayed with me longer than I expected, because I realized something troubling. She wasn't here to win a case. She was here to test the system, and people who test systems usually already believe they are above them. As the first witness was called, I noticed Daniel finally move, just slightly. He adjusted his posture and whispered something under his breath that no one else could hear, but I caught it, and I still remember it perfectly. It's starting again. I didn't know what he meant at the time, but the way he said it sounded less like a statement and more like a warning he had said before many times. I signaled for the witness to proceed, but in that moment, I felt it clearly. This case was not about damages. It was not about harassment. It was about something far more unstable sitting in that defendant's chair. And I had a growing suspicion that the real story had not even begun yet. because Karen had stopped speaking, but her smile had returned. And this time, she looked like someone who was waiting for a specific moment to break everything open, a moment I had not yet seen coming. And when I glanced at Daniel again, Abe noticed something on the table beside him, a sealed envelope that no one had mentioned in the filings, no one had submitted into evidence, and yet it was already here waiting. I remember the exact moment my attention locked onto that envelope. It was sitting on the edge of Daniel Carter's table, neatly placed, almost too deliberately positioned, as if someone wanted it to be seen at exactly the right time. But in my courtroom, nothing appears without consequence. I leaned slightly forward. "Counsel," I said calmly, "what is that envelope on the plaintiff's table?" Olivia Bennett turned immediately. Her expression changed for the first time, not fear, but confusion. And that, in my experience, is often more dangerous. "I didn't place that there, Your Honor," she replied. That single sentence changed the entire atmosphere. Because if neither the court clerk nor the counsel had introduced it, then someone in this room had already crossed procedural boundaries, and I had not yet been told how Daniel Carter didn't look at the envelope. That was the second strange detail. Most people, when something unfamiliar appears near them in a courtroom, instinctively acknowledge it. But Daniel acted as if it had always belonged there, as if it was not evidence, but memory. I shifted my gaze toward Karen Mitchell. She was smiling again, wider now, not nervous, not defensive. That's when I understood something unsettling. She wasn't reacting to the trial. She was anticipating it. The clerk whispered to the bailiff. Papers were checked. Security exchanged brief glances. I saw the subtle movement around the room, the kind that only happens when order is quietly being questioned. I tapped the bench once. "Do not open that envelope yet," I said firmly. Karen laughed, not loudly, but just enough to be heard. "That's funny," she said, leaning back in her chair. "You act like you're still in control." A ripple moved through the courtroom, and I felt it too. Not loss of control, but resistance against it. The bailiff stepped forward slightly, waiting for instruction. My instinct told me to secure the evidence immediately, but my training told me something else first. In courtroom psychology, the person who introduces uncertainty early is often the one controlling the narrative later, and Karen had just introduced something very precise. Not chaos to Reich. I turned back to her. "Ms. Mitchell," I said, measured, "did you authorize or bring that envelope into this courtroom?" She tilted her head. "I don't need to bring anything into your courtroom," she replied. "Things just end up where they belong." That sentence stayed in the air longer than it should have. Daniel finally spoke, quickly, almost reluctantly. "That wasn't supposed to be here," he said. And for the first time, his voice carried something I hadn't heard before. Not confidence, but concern, real concern. I studied him closely because that reaction told me more than any document could. If he was involved in planting it, he would have denied it immediately. If he was unaware but confident in his defense, he would have ignored it. But he didn't do either. He recognized it, which meant he had seen it before. The courtroom began to feel tighter. Even the jury members shifted in their seats, their attention now divided between testimony and the silent object on the table. I made my decision. "Bailiff," I said, "retrieve the envelope." The moment the bailiff stepped forward, Karen's posture changed, not dramatically, but enough for me to notice a subtle straightening, a readiness, like a performer just before the spotlight turns on. The bailiff picked up the envelope carefully and handed it to me. It was unmarked, no case number, no court stamp, no chain of custody indication. That alone was a violation of procedure. I held it in my hands for a moment, and I noticed something else. It was already opened. Someone had sealed it again, poorly. If urgency had overridden precision, the courtroom was silent. Even the air felt suspended. I looked at Karen once more. "Do you want to explain this?" I asked. Her smile softened, almost satisfied. "I was wondering when you'd get to that part," she said. Then she added something that made the entire courtroom go still. "That envelope isn't evidence in this case. It's evidence of what you've all been ignoring for years." Daniel's hands tightened slightly on the table. Olivia leaned forward, and I realized with growing discomfort that this trial was no longer about the complaint listed on paper. It was about something that had been waiting long before this courtroom ever assembled. I broke the seal slowly, carefully, and when I unfolded the first page, AB saw a name. Not Daniel Carter, not Karen Mitchell, but someone entirely unexpected, a third name connected to neither party officially, yet somehow central to both. And that is when I realized the most dangerous trials are not the ones that begin in court. They are the ones that arrive already in motion. I hadn't even finished reading the first line when I noticed Karen lean forward slightly and whisper under her breath, "Now it starts." The moment I read that first line, I felt something I rarely admit from the bench. Not legal hesitation, but human. The document in my hands was not formatted like standard evidence. No formal declaration, no attorney letterhead. Just typed text, uneven margins, and a tone that felt less like a legal submission and more like a confession that had been rewritten in a hurry. And then I saw the name clearly. A third name, Michael Reeves, neither plaintiff, neither defendant, not listed in the case file at all. But the moment I read it, I saw Daniel Carter's expression change, not surprise, recognition. That single detail shifted everything I thought I understood about this case. I slowly looked up from the paper. Mr. Carter, I said carefully, why is this name appearing in a document addressed indirectly to this court? Silence, longer than normal. Daniel's jaw tightened, and then he spoke in a way that surprised even me. That name shouldn't exist in this case, he said. I've spent decades listening to people lie, distort, and selectively admit truth. But there is a difference between denial and displacement. Daniel wasn't denying the name. He was rejecting its presence in this moment, as if acknowledging it would open something he had been carefully keeping closed. Olivia Bennett immediately leaned in. Your Honor, I request clarification. This document was not part of discovery. She was right. It wasn't. And that made it even more concerning, because if it didn't come through legal channels, then it came through intent. I turned my gaze back toward Karen Mitchell. She was watching me, read every word, not impatient, not nervous, patly satisfied, like some observing a sequence she had already rehearsed. Ms. Mitchell, I said slowly, explain the origin of this document. Leaned forward, and for the first time, her voice dropped slightly, not softer, but more focused. I didn't write it, she said, a pause, but I made sure it ended up exactly where it needed to. That sentence alone violated every procedural instinct I had. Because in court, control over evidence chain is everything, and she had just admitted she interfered with it intentionally. The bailiff shifted, the prosecutor whispered something under his breath. Even the jury foreman adjusted his posture. Now fully aware that this was no longer a simple civil dispute, I looked down again at the document. The third name, Michael Reeves, was followed by a short paragraph, a single line that read, he was never supposed to testify. I felt the temperature in the courtroom change. Not physically, because testimony implies existence, and that line implied removal. Olivia broke the silence. Your Honor, I move to strike this entire document as irrelevant and potentially prejudicial. But I didn't respond immediately, because Daniel Carter did something I didn't expect. He stood up slowly, without being asked, without permission, and in my courtroom, that alone is enough to draw immediate sanction. But I didn't stop him, because I saw something in his eyes I could not ignore. Not defiance, not anger, but fear he had been trying to suppress for a long time. I need to say something, Daniel said. Karen's smile widened almost imperceptibly, and that small reaction told me everything. She wanted him to speak. I leaned forward. Proceed, I said carefully. Daniel took a breath, and then he said the words that changed the entire direction of the trial. That document is about what happened before this case ever started. A murmur spread through the courtroom. Olivia turned toward him sharply. Even the jury looked confused now, sensing the ground beneath them shifting, Daniel continued. And if Michael Reeves is mentioned, then you need to understand something important. He paused. For the first time, his composure cracked just slightly. He didn't disappear by accident. The courtroom went completely still. I remembered distinctly the sound of a pen dropping somewhere behind me, not loud, but sharp enough to cut through silence. Karen leaned back again, satisfied. Like she had just unlocked the next phase of a carefully controlled sequence, and I realized something I did not want to admit. She hadn't just disrupted the case. She had structured it, the envelope, the name, Daniel's reaction, even my questions. All of it was being pulled into a direction I had not authorized, and then Daniel looked directly at me. Your Honor, he said quietly, if that document is real, then this court is already involved in something much bigger than any of us understood. That was the moment I felt at the shift. Not just in testimony, but in responsibility, because judges are trained to control proceedings. But no training prepares you for the moment when proceedings begin to control you. I placed the document down slowly and looked at Karen Mitchell one more time. Her smile had now faded, not into seriousness, but into expectation, like she was waiting for me to make a decision I had not yet realized I was already being forced toward. And before I could speak, the courtroom doors behind us suddenly opened. Every head turned, including mine, and what I saw standing there made Daniel step back half a step without realizing it, because whoever had just entered was not supposed to be alive in this case. The doors remained open for just a moment longer than they should have, That's what I remember most clearly, not the person who entered first, but the hesitation of the courtroom itself, as if even the building was unsure whether it should allow what was about to happen. And then I saw him, Michael Reeves, or at least the man identified as Michael Reeves in the document I had just read, except there was a problem. According to the case file I had been briefed on before proceedings began, Michael Reeves was deceased, a certified report. Signed, filed, closed, yet here he was standing at the back of my courtroom, alive, and very much aware that every eye in the room had just locked onto him. I have presided over many moments where truth and testimony collide, but nothing compares to the psychological rupture that occurs when official record and physical reality disagree. The human mind resists it, the system resists it, even I resisted it briefly. Daniel Carter turned slowly, and when he saw him, his entire posture changed. Not confusion, recognition, but deeper than that. A combination's relief mixed with fear. Unless someone has been carrying a truth alone for too long, Karen Mitchell didn't turn immediately. She already knew he was there. That realization settled in my mind like a cold weight, because if she expected him, then this was not emergence. It was timing. I tapped the bench once. "Security," I said firmly. "Close those doors." But I noticed something unsettling. The bailiff didn't move instantly. Not disobedience, hesitation, because the atmosphere in the room had shifted from legal proceedings to something closer to revelation. Michael Reeves stepped forward, slowly, hands visible, no aggression, no panic, but every step he took felt measured, like someone walking into a space they had already mentally rehearsed entering. Olivia Bennett leaned toward Daniel. "What is happening?" she whispered urgently. But Daniel didn't answer. His eyes stayed fixed on Michael. As if he was confirming something only he could understand, Karen finally stood, and when she spoke, her voice was calm, too calm. "I told you," she said, looking directly at me, "this case was never just about damages." I felt the room tighten again, because calm defendants are far more dangerous than emotional ones. Emotional people react, calm people execute intent. Michael stopped near the witness stand, and then he did something that made the entire courtroom shift again. He looked at me directly. Not like a defendant, not like a witness, like someone who understood exactly how fragile the structure of this courtroom actually was. "Your Honor," he said quietly, "I was never supposed to be in any official record." A pause. "And that is exactly why I am here." I felt my grip tighten slightly on the bench, because that sentence carried an implication that went beyond testimony. It suggested removal from the system itself. Treasurer Olivia stood immediately. "Objection! This is completely improper. This individual is not listed in any witness disclosures." And for the first time, Karen laughed again, but this time there was no amusement in it, only confirmation. "Counsel can object all she wants," Karen said, "but he's the only reason any of this started making sense." Daniel finally spoke again. His voice was quieter now, more controlled but heavier. "You weren't dead," he said to Michael, a simple statement, but the courtroom reacted instantly, because that was not a legal argument. That was personal history breaking into legal space. Michael nodded slightly. "No," he replied, "I wasn't dead." A pause, but I was erased. Silence hit the courtroom like a physical force. I remember the jury members shifting again, this time not out of confusion, but discomfort. Because the concept of erased in a courtroom is dangerous. It implies manipulation of records, of systems, of truth itself. I leaned forward. "Mr. Reeves," I said carefully, "you will explain your presence in this courtroom and the meaning of that statement." He took a breath, and then he said something that I will never forget. I was the original witness before someone decided I should never testify. Karen didn't react. Daniel did. His hands clenched, and I saw it clearly now. This wasn't a dispute anymore. This was a buried sequence of events finally colliding with the present. Olivia turned toward Daniel sharply. "Why didn't you disclose this?" she demanded. Daniel shook his head slightly. "I couldn't," he said, a pause, "because I didn't know he was still alive." That was the moment everything in the courtroom fractured into competing realities. One record said dead, one man stood alive, one defendant claimed control over timing, and one plaintiff looked like he had been carrying a truth too heavy to fully reveal. I looked at Karen Mitchell again. Her expression had changed, not satisfaction anymore, but anticipation, like the final pieces of a puzzle had just aligned exactly as she intended. And then Michael said the final sentence of the moment. "I didn't come here to testify about what happened." He paused. "I came here to testify about who made sure I never could." And for the first time in my entire career, A.B. realized the defendant was not the center of this case. She was the conductor of it. And whatever truth was about to surface next had already been set in motion long before I ever called this court to order. Michael Reeves' last words did not echo in the courtroom. They hung in it. There is a difference. An echo fades. A hanging silence grows heavier the longer you sit with it. I came here to testify about who made sure I never could. I remember looking across the courtroom at that exact moment, scanning faces the way I've trained myself to do for decades. Jerry remembers frozen. Olivia Bennett no longer writing notes, Daniel Carter staring at the floor like he was trying to remember something he had spent years burying, and Karen Mitchell still. Completely still. That was the detail that told me everything, because in a courtroom full of shock, the only person who remains calm is usually the one who already knows how the story ends. I leaned forward slightly. Mr. Reeves, I said, carefully controlling my tone, you are alleging interference with a witness. That is a serious claim. You will provide facts, not implications. He nodded once, not defensive, not emotional, like he had been waiting for permission to finally speak freely. I understand, Your Honor. Then he turned slightly, not toward me, but toward Daniel. And that shift alone changed the emotional direction of the room again. Daniel didn't do it, Michael said, a pause, but he was close enough to it to get buried in it. Olivia immediately reacted. That is vague and non-responsive, but I raised my hand, not to silence her permanently, but to understand, because in my experience, people don't speak in fragments like that unless they are trying to protect themselves from something larger than the courtroom. Michael continued. The night I was taken off record, I was scheduled to testify in a civil harassment case. He looked briefly at Karen, and she knows exactly what case I'm referring to. Karen tilted her head slightly, not denial, not confirmation, something more unsettling. Memory acknowledgement. Daniel finally looked up, and for the first time, his voice carried frustration. You said you were dead, he said. Michael nodded. That's what the system recorded. A pause. But I wasn't dead in the way people think. He tapped his chest lightly. I was legally erased before I physically disappeared. The phrase landed heavily, legally erased. I have heard many terms in my courtroom, dismissed, sealed, expunged, but never that one spoken with such certainty. Olivia turned toward me again. Your Honor, this is becoming speculative. This witness is introducing narrative without verifiable evidence. But I didn't respond immediately because Karen finally moved. Slowly, deliberately, she stood up again. And when she spoke, her voice was no longer playful. It was precise. You keep asking for evidence, she said, looking directly at Olivia. But you're missing the point. She turned slightly toward the jury. This isn't about what you can prove. A pause. It's about what you were allowed to forget. A ripple moved through the courtroom again, but this time it wasn't confusion. It was discomfort, because people don't react strongly to confusion. They react strongly to implication. Daniel stepped forward slightly. Karen, he said, voice tightening, what did you do? That was the first time he addressed her directly without fear of consequence. And she smiled faintly, not cruelly, but knowingly. I didn't do anything, she said softly. I just made sure the right people stopped talking at the right time. Silence again, but different this time. This silence had structure. Michael exhaled slowly and then said something that made my attention sharpen immediately. There was a third person. I felt the courtroom tighten again because up until now we had two sides, plaintiff and defendant, witness and system, but a third person changes everything. Karen didn't react, Daniel did. Immediately, his eyes widened slightly. No, he said under his breath. Michael nodded. Yes, he turned back toward me. The document you read earlier, the one with my name? Nodded. It wasn't the full record. He paused. It was only the part they forgot to destroy. Olivia looked at me sharply. Your Honor, I move to suspend testimony pending verification of identity and admissibility of this witness. But before I could respond, Michael placed something on the witness stand, a small folded piece of paper, old worn, not part of the envelope, something separate, and when he unfolded it, even I felt my expression tighten slightly. It was a court stamp. Yeah. Older case reference number 1 that matched nothing in the current docket, and beneath it, a single handwritten line. Case reopened under sealed directive. I looked up immediately. Where did you get that? I asked. Michael didn't answer right away. Instead, he looked at Karen, and for the first time, there was hesitation in her expression, not fear, but calculation breaking slightly. I got it, Michael said slowly, from the person who made sure I would come back at the exact moment it mattered. A pause, and that person is still in this courtroom. The room froze again. Daniel turned his head slowly. Olivia looked around. The jury shifted uneasily. Even the bailiff scanned the room now, and I felt something I rarely allow myself to acknowledge, loss of procedural control. Because every courtroom operates on a fundamental assumption that all relevant parties are known, identified, present. But now, someone had just been added to the system mid-trial, and no one knew who it was. Karen finally spoke again, softly, almost satisfied. I told you, she said, barely audible. This wasn't random. And then she looked directly at me. And in that moment, I understood the most dangerous possibility of all. This wasn't a case that unfolded in my courtroom. It was a case that arrived already arranged with me inside it. And before I could speak, Michael added one final sentence. The third person is the one who told me the judge would eventually ask the right question. And every eye in the courtroom slowly, unintentionally, began to shift toward me. For the first time in my entire career, I felt the weight of a courtroom shift away from the evidence and toward the bench itself, not metaphorically, physically. It was subtle at first, the kind of psychological redirection that happens when attention is slowly stolen from the facts and placed onto a single focal point. Me, the judge, Michael Reeves's last sentence still lingered in the air like a live wire. The third person is the one who told me the judge would eventually ask the right question. I remember not speaking immediately. That silence was intentional, because when a courtroom starts watching the judge instead of the trial, any immediate reaction becomes part of the narrative. And I refuse to become part of a narrative I don't understand. I leaned back slightly. My eyes moved slowly across the room. Jerry, uneasy, confused, searching for direction. Olivia Bennett, frozen between objection and disbelief. Daniel Carter, now visibly shaken, as if pieces of a memory were forcing their way to the surface, and Karen Mitchell, still calm, still seated, but her calmness was no longer passive, it was anchored, like she had just reached the point she had been guiding everything toward from the beginning. I tapped the bench once. "Mr. Reeves," I said firmly, "you will clarify that statement immediately." Michael nodded, but before he spoke, Karen interrupted. Not loudly, not aggressively, precisely. "You don't need clarification," she said, a pause. "You need confirmation." That sentence alone changed the tone of the room again, because confirmation implies pre-existing knowledge. And pre-existing knowledge implies involvement. Olivia immediately stood. "Your Honor, this is now becoming an attack on the integrity of the court itself. This witness is introducing conspiratorial framing without any evidentiary basis." But I didn't respond to her yet, because I was watching Daniel. And Daniel was doing something I needed to understand. He was not reacting to Karen, not reacting to Michael. He was reacting to me, like he was waiting to see whether I would deny what was being implied. That is when I realized something critical. In high-pressure testimony, truth is not revealed by what is said, but by what people expect the authority to deny. I looked at Michael again. "Explain," I said. He inhaled slowly, and when he spoke, his voice was quieter now, not weak or controlled. "The third person is not a participant in the case," he said. A pause. "They are the architect of its timing." The word architect settled heavily in the courtroom because it implies structure. Dines, dend. Olivia whispered again, almost to herself. "This is not admissible." But her voice lacked conviction now, because admissibility is a concept that depends on reality being stable, and reality in my courtroom was no longer stable. Michael continued. "I was approached before my scheduled testimony years ago." He looked briefly at Daniel, not by Karen. A pause. Not by Daniel. He then looked at the jury, but by someone who understood exactly how long it would take for a sealed case to surface again. I felt my grip tighten slightly on the bench, because that detail removed randomness from the equation. This was not chaos. It was scheduling. Karen leaned forward slightly. "For the record," she said calmly, "this court didn't summon him." A pause. "It was always going to be this court." Daniel finally spoke again, but his voice was different now, less defensive, more searching. "Michael, who told you that?" he asked. Michael hesitated for the first time, and that hesitation mattered more than any answer, because hesitation is where fear lives. He looked at me, and then he said it. "The person who signs your sealed oversight reviews." The courtroom went dead silent. Even the bailiff stopped moving. Olivia turned toward me sharply. "Your Honor, this is an allegation involving judicial administration." But I didn't react outwardly, because inside that moment, I was not processing accusation. I was processing implication. Sealed oversight reviews are not public knowledge, not something discussed in open court, not something known to witnesses. Michael continued carefully. "They told me the judge would ask for an anomaly in the record," a pause, "and when he did, I was to appear." I felt a cold clarity forming now, not panic, not confusion, but structure revealing itself. Because if what he said was true, then this witness did not enter this courtroom voluntarily in the traditional sense. He was positioned like a variable in a controlled environment. Karen finally spoke again, softly, almost satisfied. "I told you," she repeated, "this case wasn't about what happened." She looked directly at me now. Its about word landed differently. Activated implies dormant systems, triggers conditions. Daniel stepped forward again. "This isn't a case," he said, voice breaking slightly now. "This is a setup." And for the first time, Appy did not correct him immediately because correction requires certainty, and certainty was beginning to slip. Michael placed both hands on the witness stand and added the final line of this moment. "I didn't come here to testify against Karen Mitchell." A pause. "I came here because the system already decided today was the day the sealed record would be forced open." Silence, heavy complete, and then Michael turned slightly toward me again. "And Your Honor, you were the trigger." The courtroom didn't react immediately after that sentence, it simply absorbed it. Like reality had paused to decide whether it still agreed to function normally, I slowly looked at Karen Mitchell, and for the first time, her expression wasn't calm, it was final, as if everything she had been guiding toward had just reached the exact point she expected, and I realized something I did not want to accept. Whatever was happening in this courtroom was no longer unfolding in real time. It had already been decided somewhere else, and we were simply arriving at it, one moment at a time. Michael's words did not leave the room. They settled into it. There is a difference every judge learns eventually. Some statements pass through a courtroom, others embed themselves into the structure of it, changing how every person inside behaves afterward. "You were the trigger." I have heard objections, confessions, and verdict-shattering testimony for decades, but that sentence did something else entirely. It reframed authority, and once authority is reframed in a courtroom, everything becomes unstable. I remember looking at Michael Reeves for several seconds without speaking, not because I didn't understand what he said, because I needed to understand what kind of system allows a witness to say that with certainty. Olivia Bennett broke the silence first. "Your Honor, this is beyond the scope of any admissible proceeding. We are now hearing claims about judicial manipulation, sealed oversight, and procedural targeting. This is no longer a civil matter in any recognizable form." For once, her voice carried genuine alarm rather than legal strategy, and she was right. This case had moved beyond its classification, but stepping down from the bench was not an option, because the moment a judge abandons structure collapses completely. I tapped the bench once, firm-controlled. But I will admit something here that I have never stated on record. That tap was not to restore order. It was to confirm whether order still responded. "Mr. Reeves," I said, my voice steady, "you will explain precisely what you mean by trigger." Michael didn't answer immediately. Instead, he looked at Daniel Carter, and that alone told me there were layers here I had not yet accessed. Finally, he spoke. "In sealed proceedings like mine," he said, "there are contingency conditions written into administrative review systems." A pause. Not dramatic, just deliberate. And sometimes, he continued, those conditions are tied to courtroom behavior. A ripple went through the jury box. I saw it immediately, confusion mixed with discomfort, because the idea that a courtroom action could activate external legal consequences contradicts how most people understand justice. But systems are rarely as simple as people assume. Karen leaned back slightly, exhaling slowly. "Not surprised," confirmed. Daniel finally spoke again, more urgently now. "Stop talking like this is normal," he said, his voice cracking at the edges. "This is not normal." Michael nodded once. "You're right," he said, a pause. This was never supposed to feel normal. Olivia turned toward me again. "Your Honor, I must formally object to the narrative direction of this testimony. It is speculative, uncorroborated, and potentially contaminating the jury." But I didn't respond immediately, because I noticed something else, something subtle. Karen's hands, they were no longer relaxed. They were still, perfectly still, as if she was no longer adjusting the outcome, because the outcome was already locked. I turned my attention back to Michael. "Explain the mechanism," I said. The courtroom went quiet again, and for the first time since this began, Michael's voice carried something closer to exhaustion. "There were markers," he said, "not in evidence files, in procedural metadata." Olivia visibly stiffened, because procedural metadata is not a phrase a witness should know, Michael continued. "Markers that track when sealed cases become unstable due to cross-case exposure." A pause, and this courtroom hit that threshold. I felt a slight tightening in my chest. Not fear, recognition of pattern, because if what he was describing existed, then this trial was not isolated. It was connected. Daniel shook his head slowly. "This doesn't make sense," he said again. But now his voice sounded less like denial and more like someone trying to hold together a collapsing timeline in their memory. Karen finally spoke again, softly but clearly. "It makes sense if you stop assuming you're inside a single case. That sentence landed harder than any accusation so far because it removed the illusion of containment. Olivia turned toward Karen sharply. Are you suggesting this court is part of a coordinated procedural structure outside this case? Karen looked at her and smiled faintly. I'm not suggesting anything, she said. I'm reminding you what you've already been shown. Silence again, but different now. This silence was not suspense. It was realization forming unevenly across multiple minds at once. Michael stepped slightly forward, and then he said the next line carefully. When the trigger condition is met, the original witness is not introduced. A pause. He is returned. That word, changed the temperature of the room, implies prior placement. Daniel stepped back slightly without realizing it. No, he whispered, but Michael nodded. Yes. And then he turned toward me again. And, Your Honor, the reason I said you were the trigger, he paused, not for drama, but for precision, is because the sealed directive required a judicial anomaly, an interruption in standard procedure initiated by the presiding authority. Olivia immediately reacted. That is not legally possible, but she stopped herself mid-sentence because she realized what she was about to say. Legal possibility is defined by systems that assume transparency. And nothing in this courtroom had been transparent for some time. Karen stood again, but this time she didn't look at anyone else. Only me. When she spoke, her voice was almost gentle. You ask why that envelope appeared, she said. A pause. You ask why Michael is here, another pause. And you're still asking the wrong question. I felt the courtroom narrow again. Because when someone tells a judge they are asking the wrong question, it means the answer has already been chosen. Karen stepped forward slightly and then said the final line of this part. The question was never what happened in this courtroom. It was whether you would reach the point where you were allowed to hear it. And for the first time, AP understood that I was no longer presiding over testimony. I was participating in its activation. I remember the exact moment that realization stopped being theoretical. It wasn't a thought anymore. It was a pressure inside the courtroom, subtle at first, then undeniable, like the building itself had shifted from observing the trial to responding to it. Karen Mitchell was still standing. Michael Reeves was still on the witness stand. Daniel Carter was no longer speaking at all. And I was no longer just evaluating testimony. I was inside its mechanism. I tapped the bench once, not for order, but for grounding. Everyone will remain seated, I said firmly. We are still in a court of law. But even as I said it, I understood the limitation of that statement. Law requires a stable frame, and the frame here was beginning to fracture. Michael looked at me again, and for the first time his voice softened slightly. Your Honor, he said, you're trying to stabilize something that was designed to destabilize under specific conditions. Olivia immediately reacted. This is entirely inappropriate framing of judicial authority, but I raised my hand not to silence her, to pause everything, because I needed clarity now more than control. Mr. Reeves, I said carefully, you will stop referring to design and conditions and explain plainly what is happening in this courtroom. He nodded, a slow, deliberate acknowledgement, and then he said it. This courtroom is the final activation point of a sealed case network. A ripple went through the jury box again. But this time it wasn't confusion. It was fear trying to find structure, Michael continued. The case you are presiding over, Daniel Carter versus Karen Mitchell, was never isolated. A pause. It was one entry point in a chain of procedural containment files. Olivia shook her head immediately. No court operates like that. Cases are independent matters of fact and law. But even she hesitated at the end of her sentence because independence assumes separation, and nothing in this room felt separated anymore. Karen finally spoke again, calm, almost instructional. You're still thinking in terms of courtroom jurisdiction, she said. A pause. This isn't jurisdiction. It's sequencing. Daniel finally broke silence again. His voice was strained. Sequencing of what? Michael turned toward him slowly. Truth exposure. The words hit harder than expected. Not because of what they meant, because of how calm he was when he said them. No urgency, no panic, as if he was simply confirming something already inevitable. I felt my attention narrow again. Because judges are trained to detect manipulation through emotional volatility, but what happens when there is none? I leaned forward. Explain the sequence, I said. Michael nodded once, and for the first time he looked almost relieved. As sealed cases age, he said, they are periodically tested for exposure risk. A pause, and when multiple suppressed records begin converging in real time, he glanced briefly at Karen. A trigger subject is identified. Olivia immediately reacted again. This sounds like coordinated fabrication of narrative. There is no legal basis for any of this, but Karen interrupted her gently. There is, she said, a pause. You just never had access to it. That line hit the room differently, not because it was loud, because it implied structure beyond visibility. Daniel stepped forward again. His voice was quieter now. Karen, what did you do to me? For the first time, her expression changed slightly. Not guilt, not empathy, but acknowledgement of role. I didn't do anything to you, she said softly. I positioned you, silence, heavy, immediate. Even the bailiff stopped shifting his stance. Michael exhaled slowly and then added the detail that changed the direction again. Daniel Carter is not the primary subject of this case. A pause. He is the secondary convergence point. Olivia looked toward Daniel sharply. What does that mean? Michael answered without hesitation. It means the case wasn't built around the conflict. It was built around his reaction to exposure. Daniel shook his head. No, he said quietly. I didn't agree to any of this. Karen looked at him directly. You didn't have to agree, she replied. A pause. You only had to be predictable. That word, predictable, landed with unusual weight because predictability is not about behavior alone. It is about system response. I felt something shift internally again, because if what Michael was describing was accurate, then Daniel Carter was not merely a plaintiff. He was a monitored variable in a structured procedural environment, and Karen Mitchell was not reacting to the trial at all. She was observing whether the system was responding correctly. I looked at Michael again. And the envelope, I asked. He nodded. That was the exposure catalyst. Olivia turned sharp. Your Honor, I must insist this is spiraling into unverifiable abstraction. But I interrupted her this time, not sharply, but firmly. Counsel? I am aware. That silence afterward was different, because acknowledgement from the bench changes the tone of everything. Michael stepped slightly forward and then said the line that tightened everything again. When the envelope was introduced into proceedings without protocol authorization, it forced a procedural breach review, a pause. And that breach review required physical witness reinstatement. Daniel's face tightened. So that's me, he said quietly. Michael shook his head. No, a pause. You're what happens when reinstatement overlaps with observation. Karen finally moved again. Slowly she sat down, and for the first time in this entire trial, her calm expression softened, not into conclusion. It's already stabilizing, she said quietly. I looked at her. What is stabilizing, I asked. She looked up at me and smiled faintly. The outcome. And in that moment, courtroom lights flickered once. Not dramatically, not like a movie, but just enough to remind everyone that even physical systems can reflect procedural strain. Michael looked at me and added quietly, we're past the point of preventing it now. A pause. Your next decision won't change what happens. It will only determine how clearly you see it. And I realized then that the most dangerous part of this case was no longer what was being revealed. It was the possibility that everything already revealed was only the minimum necessary truth required for what was still coming. The lights in the courtroom steadied again, but something in the atmosphere never returned with them. It's a detail people don't usually notice when they hear about trials like this. They think tension rises and falls in obvious waves. In reality, once a certain threshold is crossed, the courtroom doesn't go back to normal. It only learns a new version of abnormal. And we had crossed that threshold. I remember sitting there, hands resting on the bench, watching a room full of people trying to unconsciously reassemble their sense of reality, jury members glancing at each other for reassurance. Olivia Bennett flipping pages she no longer trusted. Daniel Carter breathing slower now, as if oxygen itself had become unreliable. And Karen Mitchell, still seated, still composed, but no longer passive. Now she looked like someone observing a system she had already completed. Michael Reeves remained standing at the witness stand, but even he had changed, less like a witness now, more like a final instrument, still waiting for its last note. I broke the silence. Mr. Reeves, I said carefully, you will state plainly whether you are claiming this court is operating under any form of external procedural governance. Olivia immediately reacted. Your Honor, that question assumes legitimacy of I raised my hand, not sharply, but enough. I am asking for clarification, I said, and that alone shifted the burden of the room. Michael nodded once. Yes, he said, one word, no embellishment, no hesitation, just confirmation. A murmur passed through the jury box, quickly suppressed by their own confusion. Because confirmation is more destabilizing than accusation. Accusations can be dismissed. Confirmations demand reevaluation. Daniel finally spoke again, his voice quieter now, not emotional, exhausted. So none of this was actually about the case, he said. Michael turned toward him. It was never only about the case, he replied, a pause. It was about how the system reacts when suppressed information crosses thresholds of exposure. Karen leaned forward slightly and added softly, and you reacted exactly as predicted. That line hit Daniel differently, not as an insult, but as a classification. Being predicted removes agency from the present moment and relocates it into pre-calculation. Daniel looked down at his hands, as if trying to locate where his own decisions had ended. Olivia stepped forward again, voice sharper now. Your Honor, this entire narrative is collapsing due to lack of verifiable structure. We are being asked to accept metaphysical claims as procedural fact. I looked at her, and for the first time, I answered without deflection. I understand your position, I said, a pause. But I also understand what is being demonstrated in front of us. That silence that followed was immediate because acknowledgement from the bench changes everything in a courtroom. Michael exhaled slowly and then said something that made my attention sharpen again. The stabilization phase is already beginning. Karen nodded slightly, as if confirming timing. Daniel looked up sharply. Stabilization of what? He asked. Michael turned toward him. The record. That word should have been simple, but here it wasn't, because record no longer meant transcripts or filings. It meant something broader, something systemic. Karen stood again, but this time she didn't address the room immediately. She looked at me directly. Do you feel it? She asked. I did not respond, because judges are not trained to validate subjective perception, but I would be dishonest if I said I did not notice it, the subtle narrowing of options, the reduction of possible interpretations, the feeling that multiple threads were converging into a single predetermined corridor. Michael stepped forward slightly and spoke again. When stabilization begins, he said, the system filters out inconsistent narrative branches. Olivia immediately responded. That is not a legal concept. But she stopped mid-sentence again because she realized something important. Legal systems only define what they expect to encounter. They do not define what they are unprepared for. Daniel's voice cracked slightly. So what happens to us? He asked. Michael hesitated for the first time in this entire sequence, and that hesitation mattered because it meant even he was approaching the limit of what he could describe. Finally, he answered, the system determines which version of this testimony becomes the final admissible reality. A pause, and the rest gets collapsed. The word "consaps" changed the room, not emotionally. Structurally, Karen nodded again, almost approvingly. Yes, she said quietly. That's the part people never notice. Olivia looked toward me now, urgency returning. Your Honor, we cannot proceed under terminology that suggests reality selection within judicial record-keeping, but I didn't respond immediately because something else had shifted. The courtroom clock, it had stopped, not broken, stopped, and no one had reacted yet. That detail mattered because it meant perception itself was beginning to prioritize other inputs. Michael noticed my gaze and followed it. It started, he said quietly. Daniel stood up again suddenly. No, he said, this is not happening. But even as he said it, his voice lacked conviction, because denial only works when the environment still agrees with it. Karen spoke softly. You're still inside the version where you think disagreement matters, she said. A pause. It doesn't anymore. I felt the bench beneath me in a way I hadn't before, not shaking, not physically changing, but conceptually heavier, as if the role itself was being reinterpreted in real time. Michael turned toward me again and said, the final line of this part, Your Honor, stabilization requires a final interpretive anchor. A pause. And that anchor is your ruling. The courtroom went completely silent again, but this silence was different because now I wasn't waiting for truth. It was waiting for definition. And for the first time in my career, AP understood that whatever I said next would not just conclude a case. It would determine which version of it was allowed to remain real. The silence after Michael Reeves's words didn't feel like an absence of sound anymore. It felt like the courtroom was holding its breath, not waiting for testimony, waiting for definition. I have delivered thousands of rulings in my career, some routine, some life-altering, but never before had I felt a courtroom treat a judicial decision like a mechanism of reality selection. Your Honor, stabilization requires a final interpretive anchor. And then that final sentence. Your ruling, I remember slowly looking across the room. Every face was now oriented toward the bench, not emotionally, structurally, as if my position had shifted from observer of law to processor of outcome. I tapped the bench once. Not for order, but to confirm something far more important, that I was still operating within the bounds of judicial function. Before any ruling is considered, I said firmly, this court will clarify one final point. My voice remained controlled. But I was now fully aware that control and influence were no longer the same thing in this room. I turned toward Michael Reeves. You have claimed that this proceeding is part of a larger procedural system involving sealed records and stabilization protocols, I said. State clearly what is the legal status of this court's authority within that system. Olivia immediately reacted. Your Honor, that question presumes legitimacy of an external framework that has not been established. I didn't look at her this time because something had changed. Objections no longer carried the same weight they used to. Michael nodded slowly, and when he spoke, his voice was quieter than before, not uncertain, but precise. This court still holds authority, he said, a pause, but not isolation. That distinction mattered, because authority without isolation is no longer absolute. It is conditional. Karen leaned back slightly, as if satisfied that we had finally reached the correct layer of understanding. Daniel looked between all of us, his voice breaking the silence. So what happens now, he asked. Michael answered without hesitation. Now, the ruling determines which version of this testimony becomes the official record. The words official record hit differently now. Because the concept had shifted from documentation to selection, Olivia stepped forward again, voice tight. This is not how judicial record-keeping functions. There is no mechanism where testimony branches into alternate admissibility outcomes. Karen turned toward her slowly. There is, she said simply. You just never saw it happen. The courtroom clock still hadn't resumed. No one commented on it now. That in itself was the most unsettling part. Human systems normalize anomalies faster than they correct them. I felt the weight of the bench more clearly now, not physically, but procedurally, as if the role itself had become aware of its own influence. I looked at Daniel Carter, and for the first time in this entire trial, I saw something that was not fear or confusion. It was acceptance of inevitability forming too early. Then I looked at Karen Mitchell. She was watching me carefully now, not anxious, not excited, evaluating, like she was checking whether the system would complete its intended cycle without deviation. And then I realized something critical. Karen had stopped trying to win the case. Michael had stopped trying to explain it. Daniel had stopped trying to resist it. And Olivia was still trying to interpret it through frameworks that no longer applied, which meant I was the only one still actively operating inside decision-making function. That realization did not feel powerful. It felt isolating. I spoke again. If what you are stating is true, I said carefully, then this court is being asked to choose between competing versions of procedural reality. Michael nodded once. Yes. A pause, and only one version can remain active. Silence. I looked down briefly at the case file in front of me. Everything within it now felt incomplete, not incorrect, incomplete, like a surface layer over something deeper that had been carefully managed. Olivia stepped forward one last time. Your Honor, I must formally object to any ruling made under conditions of procedural ambiguity and unverifiable systemic claims. Her voice was firm again, but it no longer carried direction. Only resistance, and resistance without a framework becomes noise. Karen finally stood again, but she didn't address me immediately. She looked at Daniel and said softly, you were never supposed to understand all of it. Then she looked at Michael, and you were never supposed to return early. Then finally, she looked at me, and you were never supposed to hesitate this long. That last line changed something subtle in the room again, not fear. Recognition of timing pressure. Michael stepped forward slightly. The stabilization window is closing, he said quietly. Daniel shook his head. No, this can't be how this ends. But even he didn't sound convinced anymore, because endings are not determined by emotion. They are determined by selection. And then all eyes returned to me again. The jury, the witnesses, counsel, Karen, Michael, Daniel, all waiting, but for final interpretation. I exhaled slowly, and in that moment, I understood the full weight of what had been placed before me. Not just a case, but a branching outcome that would determine what version of everything remained coherent in the record going forward. I looked up and prepared to speak the ruling that would finalize the only reality this courtroom would be allowed to retain. The entire courtroom was still waiting, not for evidence anymore, not for testimony, but for me. For the ruling that would decide what this entire sequence would become in the official record of this court, and what version of reality would be allowed to remain coherent after today. I remember looking down at the case file one final time. Everything in it now felt strangely distant, like it belonged to a simpler version of this trial that no longer existed. Then I looked up. Daniel Carter stood rigid, exhausted in a way that went beyond physical fatigue. The kind of exhaustion that comes when a person realizes the truth they've been carrying is no longer fully theirs. Karen Mitchell remained seated, calm, but no longer smiling. Michael Reeves stood at the witness stand, watching me with quiet focus. As if even he understood that everything now depended on interpretation, Olivia Bennett was the only one still anchored in traditional law, still holding on to procedure, still waiting for a structure that had already begun to dissolve around her. I spoke, and when I did, my voice was quieter than it had been at any point in this trial, but it carried further. This court has heard testimony that challenges the boundaries of standard procedural understanding. I began, a pause. And I want to be absolutely clear about one thing. I looked directly at Michael. Court authority does not extend beyond law. Then I shifted my gaze. But law does require one thing above all else, consistency. The room stayed silent because consistency is the foundation of admissibility. And inconsistency is where doubt lives, I continued. The court cannot validate claims of external procedural systems, sealed behavioral triggers, or narrative selection mechanisms without verifiable legal grounding. Olivia exhaled slightly, as if she had been waiting for that line, but I wasn't finished. However, that single word changed the atmosphere again. The court can evaluate credibility, motive, and impact of testimony within this proceeding. I looked at Karen. For the defendant, Karen Mitchell. Her expression didn't change, but I noticed something subtle now. She was no longer guiding the room. She was observing whether the room would align itself correctly. I continued. The court finds that repeated attempts were made during this proceeding to introduce extrajudicial narrative framing that cannot be substantiated within legal record. A pause. However, it also finds that such testimony does not alter the underlying admissible facts of the original complaint. Daniel's shoulders dropped slightly, not relief, but exhaustion of tension that had nowhere left to go. I turned to Michael Reeves. As for your testimony, I said carefully, this court acknowledges your statements regarding procedural irregularities, but cannot incorporate them into the official judgment without evidentiary validation within this jurisdiction. A pause. But it does not rule on the truthfulness of your personal account. That distinction mattered. Truth and admissibility are not always the same thing. Then I said the final procedural words. This court now returns to the original matter before it. I paused. And for the first time, I felt the courtroom stabilize, not into mystery, not into conspiracy, but into legal structure again. I find in favor of the plaintiff, Daniel Carter. A wave of reaction moved through the room. Olivia exhaled fully. Daniel blinked, as if he wasn't sure whether he had heard correctly. Karen remained still. No protest, no interruption, just acceptance, I continued. Damages are awarded according to statutory guidelines presented by counsel. I tapped the bench once. Court is adjourned. The sound of the gavel should have ended everything. But as I lowered my hand, I noticed something that stayed with me longer than the verdict itself. Michael Reeves did not leave immediately. Instead, he looked at me one last time, not as a witness, not as part of a system, but as someone confirming something privately understood. Then he spoke softly. It always resolves like this on record, he said. A pause, but not always in memory. And then he turned and walked out. Karen stood next. But before leaving, looked at me, not with anger, not with defeat, but with something closer to acknowledgement, as if I had passed a test I never agreed to take. She left without another word. Daniel remained for a moment longer, then quietly followed. And just like that, the courtroom began to empty, but I stayed seated because judges do not leave immediately after rulings like this, not because of procedure, but because of reflection. I looked at the empty witness stand, at the bench where testimony had fractured reality itself. And I realized something I have never spoken aloud before. Every courtroom tells you a story, but some cases don't end when the verdict is delivered. They end when the mind decides what version of it to keep. I closed the file slowly and said quietly to myself, I don't know what truth was fully inside that courtroom that day. A pause. But I do know this. I looked up at the empty room. The law can only preserve what it is allowed to record. And sometimes that is not the same thing as everything that happened. The lights dimmed as the court emptied completely. And even now, years later, AP still asks myself one question I never managed to answer fully. If a courtroom reaches a verdict that satisfies the law, leaves part of reality unspoken, then what exactly has been decided and what has been left behind? The case was closed, but the silence it left behind never really was.